So Frank, I see you have your hand raised. Is there some, were you trying to get my attention or is there someone else? All right. It's after 6 now, so I guess I can get started. I wasn't sure if Erica was going to be on to start, but I think I can just get started unless anyone objects. My name is Caitlin Culbertson. I'm an attorney with Klein Thorpe and Jenkins. And I'm going to be presenting. Sorry, was someone trying to say something? Never mind, I apologize. The trouble with our, the Zoom interface. So I'm going to be presenting today on training for some zoning rules, procedures, principles, hardships, and voting related issues. I know we're here tonight and we're not in a public meeting capacity for the commission. So we don't want to, have any discussions about any village related items. If anyone has any questions, you can chat to me or we potentially do some sort of breakout or something like that. I also, myself, and if you've had the chance to meet Greg Smith, who's one of my colleagues that works with the village a fair amount as well, are always happy to answer questions. You're always welcome to shoot us an email or give us a call if you have any questions. You can get our contact information is on the handout that I believe you all received. It's also on our website. And so we're always happy to take questions and provide some guidance on any zoning or related matters. So the first thing I'm going to touch on tonight is just the general municipal zoning authority. So, and everything I'm saying tonight, I believe you all received a handout that if you, I'm sorry, is someone having an issue joining? Maybe I'll just give it a moment. Um, is someone can unmute themselves and tell me if there's someone's trying to get into the chat. I'm not sure what's going on the shared screen. I'm just going to continue with the training. If anyone wants to interrupt me to stop me, please feel free to do so. So the General Municipal Zoning Authority. So the Municipal Zoning Authority is derived from the Illinois Municipal Code. The United States Supreme Court, has also recognized the authority of local governments to regulate the use of land through zoning ordinances, a valid exercise of a municipality's police power. For the village specifically, the specifics relating to the zoning authority can be found in the village's zoning ordinance, which is Title 15 of the East Dundee Village Code. When analyzing the validity of a zoning ordinance, you'll hear a lot about the LaSalle factors, especially if you're talking to attorneys. The LaSalle factors are what a court will look at to determine whether a specific ordinance is valid. So it's a court case that was decided many years ago that still holds up today, relating to the factors that a court will look at in determining the zoning case. So under Illinois law, zoning ordinances are presumed valid. A zoning ordinance will be held to be an unconstitutional exercise of police power only upon a showing that the ordinance bears no substantial relationship to the general welfare. The presumption of the validity of a zoning ordinance can only be overcome by clear and convincing evidence, and the burden of proof of overcoming this presumption is on the challenging plaintiff. So the validity of each zoning ordinance must be determined on its own facts and circumstances. So it's a case-by-case analysis. And in determining the validity of a zoning ordinance or decision, Illinois courts will attempt to balance a variety of factors and determinations. And in order to assist the court in making such a determination, the Illinois Supreme Court in the LaSalle Bank case came up with 6 factors, which are called the LaSalle factors, that can be taken into consideration in determining the validity of a zoning ordinance. So the LaSalle factors include the existing use and zoning of nearby property, the extent to which property values are diminished by the particular zoning restriction, the extent to which destruction of property values of plaintiff promotes the health, safety, morals, and general welfare of the public, the relative gain to the public as compared to the hardships imposed by the individual property owner, the suitability of the subject property for zone purpose, and the length of time the property has been vacant as zoned, considered in the context of land development in the area in the vicinity of the subject property. In addition to these 6 LaSalle factors, the Illinois Supreme Court added 3 additional factors in the Sinclair pipeline case. So these factors then, these additional 3 include whether a comprehensive government zoning plan for land use and development exists, whether the zoning ordinance is in harmony with the comprehensive government zoning plan, and evidence or lack of evidence of community need for the proposed use. The factors of a particular case will determine the validity of a zoning ordinance, and no one factor is controlling over the others in the determination. So the courts, look at all the factors with the circumstances involved, and the courts have not ever indicated that one is a dominating factor. However, Illinois courts appear to place substantial importance on the first of the LaSalle factors, which is regarding the existing use and zoning of nearby property. So now that we've kind of have a general overview of zoning ordinances in general, we're going to look at the specific administration of the village's zoning ordinance. So the village's Planning and Zoning Commission, which is you, are given certain powers and duties under the Illinois Municipal Code. First of all is related to the village's comprehensive plan. The Illinois Municipal Code provides that municipalities have the power to prepare a comprehensive plan, which East Dundee has done. Specifically, the Planning and Zoning Commission is authorized to prepare and recommend to the corporate authorities a plan for the present and future development or redevelopment of the municipality. It's also empowered to make changes from time to time of the comprehensive plan and to prepare and recommend plans for specific improvements. So the comprehensive plan addresses various elements regarding the future of the municipality, including future use, public water service, school sites, public facilities such as convention centers, and expansion areas for various institutions. And if we look back at the Sinclair factors that were added to determining the validity of a zoning ordinance, one of them went to whether or not municipality had a comprehensive plan. So since East Dundee does have a comprehensive plan, if a zoning ordinance is challenged, one of the factors that a court would look at is whether or not the ordinance is in line with the village's current comprehensive plan. So specifically, if you were going to process a change to the comprehensive plan, you would make a recommendation regarding any change to a comprehensive plan, and the final decision and action will be taken by the village board. So specifically, the Illinois Municipal Code provides municipalities with broad authority to zone and to regulate. Some of the specific things that the municipality is authorized to do is to regulate and limit the height of buildings to be erected in a municipality, establish setbacks and building lines on or along streets, traffic, driveways, stormwater and flood runoff and channel basins, regulate the intensity of use areas and the density of areas, classify and regulate and restrict the location of trades and industries to specific locations, which is your business and commercial districts, and divide the entire municipalities into districts such that can have different zoning and regulations amongst them. It can also prohibit uses, buildings, or structures incompatible with the character of such districts. So you can, as you know, you can have residential districts and restrict, any type of industry or commercial businesses from operating within those residential districts. Now we can look specifically at special uses. Special uses are things that you're going to see a lot of, I imagine. They're going to come to you, and so you have to be familiar with what a special use is and when they can be granted under what circumstances. So first, what is a special use? So the village, as we just said, is divided into zoning districts as outlined in the zoning ordinance and the village's zoning map. For example, you have the R1 single family residence district, which is designed for single family detached dwellings. Generally, no zoning relief is necessary when the use of the property is in compliance with the list of permitted uses within that zoning district. So if you wanted to have a single family home in the R1 district, you would be able to do that. You wouldn't need any zoning approvals for that unless there was a circumstance with a setback line or something else that we can get into later. The zoning ordinance also includes a list of special uses for each zoning district. For example, in the B3 service business district, a bowling alley is a special use. These special uses are only allowed in a zoning district where the Board of Trustees, upon the recommendation from you as a commission, following a public hearing, have found the proposed use to be compatible with the neighborhood and have granted a special use permit at the request of the property owner or the interested party. In deciding whether to grant a special use, you are to consider various factors, including the effect of the proposed special use on neighboring properties and its effect on the general public, the health, safety, morals, comfort, and welfare of the area. So, basically, when someone comes to you asking to have a different type of use in the area, you want to make sure that it's not going to harm any of the properties that are adjacent to it. Special uses are also specifically allowed under the Illinois Municipal Code, excuse me. So the special use technique allows municipalities to provide for uses that may be appropriate in a particular zoning district, but may require special regulations because they're unique or unusual with their impacts that they might have. Placing these uses on the special use category allows municipality to examine the uses on an individual basis, rather than just allowing them as a permitted use. And then only after review under the standards of the zoning ordinance, they can impose then you can allow them and impose reasonable restrictions that make them more compatible with the zoning district in which they are located. It is important to note that, however, that the special use technique cannot be used to prohibit otherwise lawful uses. And that's, for example, the First District Appellate Court said that the denial of a fast food restaurant special use request was unreasonable because it could not prohibit that use entirely, but it still recognized the authority to impose reasonable conditions on the approval of that special use permit. So the village in its village code has set forth standards for issuing a special use permit. The standards that the commission and then the village board must consider are set forth in section 157.224 of the zoning ordinance. And according to this section, the corporate authorities may adopt an ordinance allowing the establishment of a special use whenever the applicant establishes that. And then there's 5 different categories that are listed. The first is the special use will not be injurious to the use and enjoyment of other property in the immediate vicinity of the for the purposes already permitted, nor substantially diminish and impair property values within the neighborhood. Second, the establishment of the special use will not impede the normal and orderly development and improvement of the surrounding property for uses permitted in the zoning district. Third, adequate utilities, access roads, drainage, or necessary facilities have been or will be provided. 4, adequate measures have been or will be taken to provide ingress and egress so designed as to minimize traffic congestion. And the special use shall conform to the applicable regulations of the zoning district in which it's located. And special use permits are under the Planning and Zoning Commission purview for the public hearings. The commission then makes a recommendation and to the village board, who makes the final decision on the special use. So that's kind of a basic overview of the special use permitting process. Those are things that will be brought to you, and you'll hold a public hearing on them, decide if they meet the standards that are set out in the village code, which we just went through. Then you will decide if you will vote on them, either to recommend approval or denial to the village board, who will then make the final decision on the special use. The next item we want to discuss are variations. The variation is a modification of the literal provision of the zoning ordinance, allowing a proponent to do something which would normally be in violation of the zoning ordinance. For example, allowing a decrease of a setback line, or allowing a increase in a lot coverage percentage, or something like that. The Illinois Municipal Code authorizes municipalities to provide relief to property owners from the strict application of the zoning ordinance when strict compliance presents a practical difficulty or particular hardship. And this language can be found in the Illinois Municipal Code. So variations then allow municipalities to provide relief to property owners from the strict application of a zoning ordinance when strict compliance presents, as I said, a practical difficulty or particular hardship. So those are important words to remember: the practical difficulty or particular hardship. And that must be determined by the commission and then the board if those are actually there. And that's the only time in which a variation should be granted. Variations should be relatively difficult to obtain and should only be granted if a proponent has demonstrated to the commission that the proponent meets the requirements of the zoning ordinance and the appropriate legal standard. These should not be things that are granted every day because they are deviating from the requirements of the village code, and they have to make sure that no precedent is set for these just to be rubber stamped or something like that. They really need to meet the standards and show that a hardship does exist in order to be granted. If the proponent does meet the required legal standard, the board should vote to grant the variation or recommend approval of the variation, rather. And then and it's important to remember that the commission should ensure that the spirit of the zoning ordinance is observed, public safety is secured, and substantial justice is done in granting or denying the variation. Variations are heard by the Planning and Zoning Commission for a public hearing, and then recommendation is made to the village board, again, who will then make the final decision on the variation. So as I said, there has to be a showing of a practical difficulty or unnecessary hardship. But these are kind of vague language, so it's important to discuss what does that mean. So in deciding whether to recommend or grant a variation, the commission must consider various factors. As the variations allow the village to provide relief to property owners from the strict application of a zoning ordinance, when strict compliance with the ordinance would present a practical difficulty or particular hardship, then which the language again is found in the sections of the municipal code, and the statute states that variations shall be permitted by the Board of Appeals only when they are in harmony with the general purpose and intent of the regulations, and only in cases where there are practical difficulties or particular hardship in the way of carrying out the strict letter of any of those regulations relating to the use, construction, or alteration of building or structures or the land or the use of the land. The village's zoning ordinance then similarly provides that the commission shall decide authorize variations of the provisions of this chapter in harmony with its general purpose and intent, and shall grant them only in specific instances where there are practical difficulties or particular hardships in the way of carrying out the strict letter of the zoning regulations of this chapter. The zoning ordinance, though, like the municipal code, does not define hardship, but that can be kind of determined based on case law and the standards that are set forth in the village code. The applicant who is requesting the variation has the burden of presenting the evidence sufficient to meet the hardship standard and to show practical difficulty or particular hardship to him or herself. If the presented evidence does not convince you that the standards are met, the variation should not be recommended to be granted. Whether a particular hardship exists is a fact-specific inquiry. So it has to be the facts and the circumstances of each case have to be looked at individually. Traditionally, variations have related to a physical characteristics of the lot as opposed to personal circumstances, wants, needs, or desires. A classic example of a hardship is an oddly shaped lot, which results in difficulties or impossibilities in complying with setback requirements. For example, if you have like a triangular shaped lot, that oftentimes requires that there's variations from the setback requirements because if your home just cannot meet them based on the lot lines. Evolving concepts of what constitutes a hardship, though, have resulted in many zoning boards looking at hardships in a more nuanced manner. For example, if you look at trees, well, 50 years ago, trees may have been viewed as largely expendable. Or more modern view of hardship might allow the location of a 100-year-old tree on a lot to constitute a hardship if complying with the strict requirements of the zoning code would require the removal in order to build a garage in that location or something similar to that. Similarly, where the location of an existing home on a lot was once viewed as irrelevant to the hardship process, many zoning bodies today would see value in making zoning decisions that allow existing non-conforming homes to be preserved. For example, if an owner of a home with historic value or pedigree wishes to update and modernize the home, modern zoning requirements may prohibit the home from being modified without a variation. If the village denies a variation request, the owner may decide to raise the home rather than live in it as is. By taking the historic value of the property into account, the village can further preservation values. So those are just some specific examples of what might come up. Determinations by the courts over the years have given some guidance on what does not constitute a hardship. courts have ruled that hardships cannot be self-created, cannot be based on a need to accommodate the size of one's family or personal health issues, cannot simply be based on a showing that the property would be worth more if the variation were granted, cannot simply be a demonstration that a property is better suited for a use than is prohibited, than a use that is permitted, does not exist simply because the cost of a project would be higher if the construction in the area would be that would be otherwise permissible, cannot be based on mere inconvenience, and cannot be granted simply because it may increase the selling or rental value of a property. So I've also, in the packet that you've been provided, we've provided a list of specific cases and examples of when Illinois courts have found hardship sufficient for variations existed, and then specific examples of when Illinois courts have found that there was not sufficient hardship to warrant variations in certain cases. So hopefully those, I'm not going to go through all of them, but hopefully those are helpful in providing some examples of what may or may not constitute a hardship, at least in the eyes of Illinois courts. So specific to the village code has standards to be applied in deciding a variation request. The Plan and Zoning Commission must apply the standards that are set forth. It's in section 157.207 of the zoning ordinance. And according to these standards, no variation from the provisions of the zoning ordinance shall be granted by the corporate authorities unless it finds that all of the following facts and conditions exist. And then there are three of those conditions. The first, the property in question cannot yield a reasonable return if permitted to be used only under the conditions allowed by the regulations in that zoning district. The plight of the owner is due to unique circumstances, and the variation, if granted, will not alter the essential character of the locality. For purposes of supplementing the above standards, the Commission, in making its decision of whether there are practical difficulties or particular hardships, shall also take the following factors into consideration, and then 6 more are listed. The particular physical surroundings, shape, or topographical conditions of the specific property involved would bring a particular hardship upon the owner, as distinguished from a mere inconvenience if the regulations were strictly enforced. The conditions upon which the petition for variation is based would not be applicable generally to other property within the same zoning classification. The purpose of the variation is not based exclusively upon a desire to make more money out of the property. The alleged difficulty or hardship has not been created by any person presently having an interest in the property. The granting of the variation will not be detrimental to the public welfare or injurious to other property or improvements in the neighborhood in which the property is located. And the proposed variation will not impair an adequate supply of light and air to adjacent property or substantially increase the danger of fire or otherwise endanger the public safety or substantially diminish or impair property values within the neighborhood. So when you get an application for a variation, these are the factors that you specifically should consider in deciding whether to recommend approval or denial of the variation. If a variation is granted, it then runs with the land, and they're not personal to the owner, and therefore if the ownership to the property changes, the variation goes with the land and continues with the property. The condition imposed with respect to the variations would also run with the land and apply to a subsequent owner of the property. The village board, like with a special use, will make the final decision as to whether or not a variation is granted or denied after the commission holds a public hearing and makes a recommendation to the board. So the next item I will discuss, however briefly, is plan development. So plan developments are more in the purview of the village board. So I won't go into them in depth, but it's important just to have a general sense of them so you have a general sense of all the different types of zoning relief that can be granted. So a plan development is a larger development in the village that requires a more comprehensive zoning review and may include consideration and approval of both special uses and variations. Section 157.240 of the zoning ordinance provides for plan developments. The the village board in these circumstances holds the public hearing and makes a recommendation on whether to approve or deny it. And in this case, you look to the village code, it gives an explanation of the purpose of the plan development, and the purpose is to provide for an alternative zoning procedure under which land can be developed or redeveloped with innovation, increased amenities, and creative environmental and architectural design than would be possible to achieve under the otherwise standard zoning district regulations, while being in general compliance with the planning objectives and intent of the zoning ordinance. Under the plan development procedure, well-planned residential, industrial, manufacturing, commercial, and other types of land uses individually or in combination may be developed with design flexibility, allowing for full utilization of the topographical and environmental characteristics of the site. In East Dundee, a planned unit development is a tract of land which is developed as a unit under single ownership or control, which includes 2 or more principal buildings and which has to be at least 2 acres in size. The sheet then, as set forth in the municipal code, goes through the procedures for going through the plan development. There's a pre-application process with the village, then a PUD plan review. The plats review, the commission does review the plat and it has a recommendation for the village board, and then the village board authorizes the final PUD plat. There's also standards to be applied under the zoning code to the applications for a planned unit development related to density, the proposed use as allowable uses in the respective zoning districts. You look at the special uses within the zoning district in which it will be located. The Planning and Zoning Commission and the village board may recommend approve access to a dwelling unit by driveway or allow for easements for off-street parking, different things like that. There also may be the Planning and Zoning Commission may also recommend, and the village board may approve, yards of lesser widths or depths than required, typically in the zoning district where the plan development necessary for the plan development. And those standards, again, that's set forth in 157.250 of the village's zoning code, and are applied on a case-by-case basis for each PUD application. Moving on to map amendments, rezoning property or text amendments, amending the village code. So a property owner or another interested party may bring you a map amendment, which is asking for the zoning of a particular property to be changed. It's called a map amendment because it is actually changing the map of the municipality, the official zoning map of East Dundee. An owner or of a residential property who wishes to convert the property to a commercial use, for instance, may petition to have the property rezoned to a commercial zoning district. There's also a text amendment, and a text amendment is a change to the actual text of the zoning ordinance. Such changes may be the result of a perceived need for a change, such as amending the code to reflect types of property uses that did not exist in the past. Map amendments and text amendments are under the jurisdiction of the Planning and Zoning Commission for public hearings and a recommendation, and then they go to the village board for the final decision. So we kind of touched on this before when we were discussing special uses, but one of the things the village really does not have the authority to do is to outright have blanket prohibitions on different uses via zoning. While there is statutory authority under which municipalities may prohibit certain uses, the general rule regarding blanket use prohibition prevails, and municipalities do not have the power to wholly restrict lawful businesses from their boundaries. There are, of course, exceptions to this. One would be when cannabis was legalized, municipalities were able to opt out and to not allow, dispensaries from operating within their jurisdictions. And that was, based on the statutory Cannabis Act. But in general, blanket prohibitions are not favored and should be avoided in enacting zoning restrictions. I provide in the handout a list of uses and businesses the municipalities may by ordinance prohibit from the Illinois Municipal Code, and that's pinballs or bowling alleys, billiards, pool establishments, which is under a section of the municipal code. The municipal code also allows runners for cabs, buses, railroad, ships, hotels, public houses, and other similar businesses to be prohibited. Pawnbrokers, transient vendors, or any offensive or unwholesome business or establishment within the municipality and within the distance of 1 mile beyond the municipal limits. So short of a blanket prohibition, municipal authority to restrict land use via zoning district is addressed in the Illinois Municipal Code, which provides that municipalities shall have the power to classify, regulate, and restrict the location of trades and industries and the location of buildings designed for specific industrial, business, residential, and other uses, to prohibit uses, buildings, or structures incompatible with the character of such uses. So I've provided then a list of some specific issues in zoning, and then there are common issues that come up and an analysis of how each one would be decided. For example, I'm kind of going through time rather quickly here, and I don't want to keep you when you can, look at these yourself. But the specific one is, contract zoning or rezoning. Is it okay? Provide an analysis of that, and then spot zoning, different things of that. So that can be helpful just to look at some issues that come up regularly with zoning and how we would analyze that issue. So public hearings, you will become very familiar with them. Each community implements the public hearing process, which is required by the Illinois Municipal Code, but implements it in its own way. Oh, I'm sorry. I'm seeing that you guys apparently did not get the handout. I will make sure that you do receive it. You don't necessarily need it as I'm going through right now. As I'm mentioning things that are in it. You will get it, and it will go over, everything I have mentioned tonight, and also have the additional materials that I'm referencing, which will provide you more specific examples of situations or, things that we've seen over the years that have come up and how we would handle them. So you don't necessarily need it right now, but I think it will be very helpful to have as a reference. So I'll make sure that you guys all receive one. Anyway, back to public hearings. So the zoning code sets forth the procedures for each type of public hearing. I won't they're each set forth in chapter 157 of the village's zoning code, and so you can take a look at that for the specifics of the public hearing process or notice requirements. Really is more, which most of the time will be taken care of by staff for each type of text amendment, a special use permit, those different types of things. But the typical public hearing procedure would be kind of would proceed under the following timeline. The commission makes and votes on a motion to open the public hearing. The chairman would make introductory remarks. There would be an oath administered to the applicant, the applicant's witnesses, objectors, and objectors to the witness. Everyone who wants to testify at the public hearing has to be sworn in because they're all providing evidence and testimony and to the board. Applicant then would present its case through its witnesses and exhibits. After each of the applicant's witness or after the applicant's case is presented, objectors are then given the opportunity to ask the witness questions about the witness's testimony. Objectors can also then present their case through witnesses and exhibits. After each of the objectors witness, the applicant, in the same manner, is given an opportunity to ask the witness questions about the witness's testimony. The applicant can then present any rebuttal witnesses or exhibits. After each of the applicant's rebuttal witnesses, the objectors then are given an opportunity to ask the witness questions about the witness's testimony. The applicant can then make a closing statement. The objector can then make a closing statement. Members of the audience who are not objectors are given the opportunity to make statements as well. The commission then makes and votes on a motion to close the public hearing. After the public hearing is closed, the commission would then deliberate, come to a consensus, and vote to make findings of fact and a recommendation to the village board. When voting on anything, you would be voting to make a recommendation to the president and board of trustees. The only time that the commission is voting to make a final decision is when you would hear an appeal to overturn a decision of the building inspector. The recommendations are made by a vote of the members present after the public hearing is concluded. A vote cast in favor of a zoning application before the board means that a member finds that all the standards relevant to the application have been met. A vote cast against an application means that the member finds that one or more of the standards relevant to the application have not been met. So if a vote is cast against an application before the commission, the member should explain at the time their vote is cast which standard or standards have not been met and how the application fails to meet the standard or standards. The explanation is important for the sake of transparency, fairness, and due process because it provides the applicant, the board, and the public with the reasoning for the vote against it. So for example, assume an application for a variation is before the commission to allow for an increase in the height of a structure. The proposed height of the structure exceeds the permitted height in the zoning district, requiring a variation. Evidence is presented at the public hearing, which shows that the proposed height of the structure would cast a persistent shadow on an adjacent property that currently receives a greater than average amount of sunlight. Evidence also shows that the applicant cannot explain a need for the height variation, except it would allow them to derive more income from the business. After hearing the testimony, a commission member decides that the application does not meet two variation standards. First, the purpose of the variation is based predominantly upon a desire for economic gain. And second, the proposed variation will impair an adequate supply of light to adjacent property. After deliberation on the application, a motion is made and seconded to make a recommendation to the village board that the application be granted. When the member's name is called to vote, the member should then state, I vote no on the application because the variation standards in section 157.207 are not met, as the variation request is predominantly based on the application's desire for economic gain and because the proposed variation will impair an adequate supply of light to the adjacent property. It's also helpful if a member is voting no on an application that it provides an alternative and an explanation to the applicant of how they could how they could improve the application or alternatives to the application, if any, where they would be able to meet the standards of the zoning ordinance. So for example, you could give that same no vote and then say, if the application were amended to reduce the requested height variation by 8 feet or more, I believe the standards would be met. If you're explaining alternatives in this way will assist the applicant and the board and the public in understanding like what changes could be made to the application so it could meet the standards. It also encourages fairness by giving the applicant an understanding of a path forward on a revised application should the application be rejected. So moving away from zoning for a moment, and I do apologize, as I have just been reminded, the commission also can issue a historic certificate of appropriateness, which is a final action by the commission where no board action is needed. So thank you for reminding me of that. Is another example of a time where you wouldn't just be recommending something, you would be taking final action on an item. So moving on from zoning for a moment, another important area is to discuss conflict of interest. In order to best serve the interests of the village, commission members must be aware of and act appropriately in light of any conflict which may be perceived as influencing their decisions. Members have a duty to act in all cases except those where a conflict of interest exists. Typical conflicts of interest include financial interests. A financial interest could include a village board member owning or having an interest in a property which is a subject of consideration. A commission member owning or having an ownership interest in a property whose value could be affected by a decision either positively or adversely. A commission member being employed by a property owner whose project is under consideration, or a commission member being employed by a planner, engineer, or law firm who's representing the proponent. Could also have a personal interest, such as being a relative of a proponent or an applicant, or a relative of someone who is objecting or in opposition to the case, or being a close friend or having a longstanding personal relationship with a proponent or opponent of a particular case. Another example of a conflict would be an association or an organization interest, which would be when a commission member is also a member of a board of directors of an association or organization, which could constitute a conflict of interest, such as where a member of the commission is on the board of directors, a proponent requesting a variance or seeking approval from the commission. There are two types of conflicts: statutory conflicts of interest and common law conflicts of interest. A statutory conflict of interest usually involves a direct contractual interest between a conflicted individual and the municipality. Where you believe this type of conflict may exist, the village administrator should be consulted immediately to determine the nature of the conflict and appropriate course of action. This is very serious, as violations of this statutory provision relative to conflicts of interest carry criminal penalties. So it's extremely important to take the appropriate course of action. More common are common law conflicts of interest. Such conflicts don't rise to the level of statutory conflicts, but instead are the result of an individual having a personal interest in a matter that he or she cannot render a fair or impartial decision. Anytime a commission member believes that he or she cannot act impartially with respect to a request, they should advise the village board of the same and disclose it publicly and refrain from acting on the request. So if a common law conflict of interest does result, a member with a potential conflict of interest should publicly disclose the conflict to the satisfaction of the full membership of the commission, so that the same becomes part of the official public record prior to any action or deliberation in the matter. A member abstaining due to a common law conflict of interest should not participate in the discussion of that item. I also want to provide you with a summary of the Open Meetings Act as it applies to zoning matters. The commission is a public body subject to the Open Meetings Act. The act makes it public policy that public bodies shall act and deliberate openly. Citizens shall be given advance notice of and the right to attend all meetings, and citizens have the right to know what is going to be discussed at the meetings. In addition to stating a general public policy of meetings of public bodies, the Open Meeting Act states that meetings of public bodies must be open to the public, makes exceptions for certain specified matters which can be discussed in closed session, requires that meetings shall be specified times and places convenient to the public, prohibits public meetings other than those that are regularly scheduled on a legal holiday. So if your meeting falls on a legal holiday, that's okay, but you can't schedule a special meeting on a legal holiday. requires notice of a meeting to be given to the general public and certain news media, requires preparation of a schedule of regular meetings, and requires publication of a change in regular meeting dates, requires preparation of minutes of all open and closed meetings, and provides both civil and criminal remedies for violations. So what is covered under the Act? Like I said, public bodies. The Open Meeting Act applies to all meetings of public bodies. Public bodies, as defined in the Act, include all legislative, executive, administrator, or advisory bodies of the village. So as I said before, the commission is covered by the Open Meetings Act. The Open Meeting Act defines a meeting as any gathering of a majority of a quorum of the members of a public body for the purpose of discussing public business. For a 7-member public body, 4 members would constitute a quorum, and 3 represents a majority of a quorum. Therefore, a discussion of public business among 3 members of a 7-member public body is covered under the Act, while a discussion among 2 members is not. So the Open Meetings Act does not actually define public business, but one can assume the term refers to business of the particular body. The definition of meeting also requires that the gathering of a majority of a quorum be held for the purpose of discussing public business. Unless the gathering is open to the public and all requirements of the Act are met, including notice and minutes, the public officials involved are in violation of the Act. It is not necessary that public officials meet at their official meeting place in order to have a meeting under the Act. Also, if public officials gather together at a social event with the intent of evading the Act, they will be in violations of the Open Meetings Act. The Open Meetings Act requires all public meetings to be held at specified times and places which are convenient and open to the public. As I said, they can't be held on a legal holiday unless a public body regularly holds them on the day and it just happens to fall on a holiday. The Act does not define legal holidays or the source of the days. However, a list of legal holidays is set out in the Bank Holiday Act. So there are notice requirements that are also provided by the Open Meetings Act. The notice provision of the Open Meetings Act established somewhat different requirements for different types of meetings. There's regular meetings, special meetings, and reconvened meetings under the Open Meetings Act. Regular meetings require each public body to give public notice of its schedule of dates, times, and places for regular meetings at the beginning of each calendar year, and to make the schedule generally available. In addition, an agenda of each regular meeting must be prepared and posted at both the principal office of the public body and the location where the meeting will be held at least 48 hours in advance of the meeting. For a rescheduled meeting, public notice must be given at least 48 hours beforehand, and the notice must include the agenda for the meeting, but no newspaper publication is required. For special meeting, public notice of special meetings, except a meeting held in the event of a bona fide emergency, must be given at least 48 hours before the special meeting, and the notice must include the agenda. In the case of an emergency meeting, notice of special meeting held in emergency must be given as soon as practicable, but in the event prior to holding the meeting, to any news mediums which have filed an annual request for notice under provisions of the Act. With respect to a reconvened meeting, when the commission finds its volume of business too great to finish in one meeting, it can opt to adjourn and reconvene to a later date. In this case, public notice of a reconvened meeting must be given at least 48 hours beforehand, and the notice must include the agenda. However, public notice is not required if the meeting is to reconvene within 24 hours, or if the date, time, and place of the meeting are announced at the original meeting and there's no change in the agenda. So if you hold, sometimes there's a very large development or there's a lot of objectors that come to a meeting, so it's a lengthy meeting. If you want to continue it to another date, if you on the record say the date and time and the place of the next meeting, then that satisfies the notice requirements. The minutes of the original meeting should show the action taken by the public body adjourning to a definite time, date, and place. The Open Meetings Act also requires or allows, excuse me, that any person may record the proceedings of any public meeting by tape, film, or other means. The public body or the act does allow public bodies to prescribe reasonable rules governing the right to record, but someone can pull out their iPhone at your meeting and record it, and that would be allowable. The Open Meetings Act also sets forth when there can be closed meetings, but that's more would be issues for the village board, so we don't need to get into that. But if you have any questions about closed meetings, I'd be happy to provide you answers to that. Members can attend electronically. Under certain circumstances, electronic attendance is authorized if the official is ill or disabled, the official is unable to physically attend because of employment or official business of the public body, or the official has a family or other emergency. And electronic attendance is only allowed where a quorum of members is physically present at the meeting site. And this is different. This is when we're not operating under the COVID emergency. That was completely separate. So under normal circumstances, the Open Meetings Act only requires electronic or allows electronic attendance under those certain circumstances. Minutes must also be kept under the Open Meetings Act. The Open Meetings Act prescribes the following minimum requirements for the minutes: the date, time, and place of the meeting, the members recorded as either present or absent, and a summary of the discussion of all matters proposed, deliberated, or decided. If Open Meetings Act is violated, as I said, they can be tried in criminal court with a Class C misdemeanor, which is punishable by a $500 fine. So we want to make sure that we follow all the requirements of the Open Meetings Act. So I'm just looking at the comments that are, see if there are any questions. That's kind of a summary of the Open Meetings Act. Yes, if the one of the comments is, which is correct, the Open Meetings Act requires organizations to post on the website if they maintain their site. So if the village has a website that's regularly maintained, so it would have to post on its website, which it does. And yes, we want to make sure the venue is suitable to having an audience or a crowd so the public can come in, because the public is allowed to comment and to speak at the public hearings. So I hope that provided a general overview of different planning and zoning issues that might come up. I know that was a lot of information to kind of throw at you. So I do hope and I hope you did learn something. And if you have any questions, as I said, I'm happy to answer them. And as I want to again point out that this meeting is not being held as a meeting of the board. It's a training for me to present information. No discussion between the board members is being had. And I'm simply, no one has been speaking or discussing between themselves. So we're not in violation of the Open Meetings Act here by me just providing a training to you. But for example, if you all had, turned on your microphones and started talking about public business, that would of course been a violation of the Open Meetings Act. So I appreciate none of you having done that. And yes, as far as electronic attendance, there was a question about, I want to point out that members who are appearing electronically under the 3 allowable ways under the Open Meetings Act would be allowed to vote. So for a long time, I imagine you were all appearing remotely under COVID, and that was because we're under an emergency declaration, and that's completely separate section of the Open Meetings Act, which allows for completely remote meetings. In a normal circumstance, again, you only can appear electronically. if you're out of town for work, if you're sick, or if you have a family emergency. And you would be able to vote and participate remotely in the meeting. So I think we're about out of time. Again, I'm going to provide these packets, or Erica or someone from the village will provide everyone with this handout that is a summary, or not a summary. It goes more in depth than everything that we discussed tonight. So hopefully that will provide a good reference for you. Okay, apparently, I believe Erica has sent them out. So you should all have received your these handouts. And if when reviewing them, if you have any other questions, please reach out to me, please reach out to Greg Smith, or I know village staff members, your building inspector, or village administrator, who are very experienced in all these areas and will be more than happy to discuss any of these questions or issues with you going forward. So I appreciate you all coming on tonight. And again, if you have any questions, please feel free to reach out to me and I'd be more than happy to discuss anything further.